report that the law on competition has not been discussed at length in the Ugandan jurisdiction, and as such, while we submit to you, you will hear us rely on a lot of persuasive jurisprudence from the European community. We only invite this Honourable Court to liberally apply these decisions and statutes so as to come up with a determination on what is fair competition in the premises. My Lord, I will now proceed to submit on issue 1. Your Lordships, issue 1 is to the effect that Green Drive's exclusive agreement with Skyconnect for access of 8G ultra-high frequencies constitutes an abuse of its dominant position. It's imperative then that we establish that there is first a dominant position, and your Lordships, I will rely on the case of La Roche versus the Commission decided by the European Court of Justice in 1971 to establish what amounts to a dominant position. And your Lordships, this decision connotes two important things. One, that an entity can behave to an appreciable extent independently of its competitors, consumers, and customers, but also that it particularly forecloses other entities from competing in the relevant market. It is therefore substantial to establish what exactly is the relevant market in the premises. My Lord, we now beg to this court and invite this Honourable Court to be persuaded by the jurisprudence of Justice Stuart Mackenzie in the case of United Brands versus the Commission of 1976 by the European Court of Justice, where he highlighted that the metric of defining what a relevant market is from the standpoint, the view from the standpoint of a product. We therefore submit that before this Honourable Court that Green Drive holds a dominant position in the relevant market of electric motor vehicles, but also in the accessory of a smart charging chip. That when you look at these two products that work concurrently and coherently, Green Drive in both markets holds a dominant position. And your Lordships, the requirement of a dominant position is that it should exercise a significant share of the market. Your Lordships, I invite this Honourable Court to paragraph 3, line 3 of the facts, where Green Drive exercises a significant share in the relevant market of manufacturing electric vehicles. I also refer you to paragraph 4 of the same facts. Green Drive has developed 8G high-frequency smart charging chips, and as such has entered even an exclusive agreement. We established that on this premise it holds a dominant position in both these markets. The Lordships, having established that there is indeed a dominant position, the question before this Honourable Court is whether the exclusive agreement then violates this dominant position. Your Lordships, we will now rely on a peripheral of laws, but firstly, we will rely on section, clause 10, subclause 6 of the competition bill that is in pending assentment in a persuasive manner. That is pending assentment of the President to become...
Pending what?
Assent. I will. Much obliged for the indulgence. Assent. Your Lordships, we will also read it together with section 6, subclause B of the East African Community Competition Act. Your Lordships, read together, these seem to suggest that an entity should not foreclose competition.
Well, you're citing the East African Community Competition Act. Please address this court on the applicability of that act, particularly with respect to the requirement that there be a cross-border effect of any alleged anti-competitive practice before that act is applicable.
Much obliged, Your Lordships. We understand and highlight the concern of the court that the East African community is only applicable if there is a cross-border effect that is not specifically highlighted in the facts. However, my lords, we submit that, as I highlighted, that the jurisdiction of Uganda in and itself has not discussed to a length competition. We invite this Honourable Court simply to infer what the Act applies for so that we can interpret and understand what the relevancy of competition to that end and what really is fair. So we only apply it persuasively, my lord. My lords, read together as I was highlighting, it seems to suggest, it suggests actually, that an entity should not enter exclusive agreements that foreclose competitors from taking part in such an essential innovation. Your Lordships, this position has been retaliated in the jurisprudence of Oscar Bonner versus Media Print of 1998, the 27th of November, by the European Court of Justice, where it highlighted that foreclosing competitors to access an essential facility of innovation, in this case a smart charging chip of 8G frequency, amounts to an abuse of a dominant position. Your Lordships, I will now move you to the second bit of violation that was done by Greenberg.
How do you balance that dominant position with the rights that come with an invention and innovation? Because in paragraph 3, we see that. Is it paragraph 3?
Yeah, it is paragraph
4. Yes. It's Green Drive that came up with this smart charging chip that intercepts 8G ultra high frequency. So it was their innovation. So how do you balance their intellectual property right to enjoy monopoly over that innovation with what you're asserting as dominant position?
Your Lordships, I will answer this pursuant to the decision of the European Court in the case of Post-Denmark by the European Court of Justice, where it highlighted that to estimate what amounts to substantial foreclosure in respecting what the non-violation of copyright and patent rights. It established that substantial foreclosure is that limits an entity, an innovating entity, from accessing what is a substantial facility to innovation. We submit that the technology of a smart charging chip to access 8G frequency is substantial to innovation, that once this is not met by other competitors, then they cannot compete on the market, but also limits innovation. My lords, we understand that there are rights that should be enjoyed by the
So what you're saying is that only that smart technology chip is the one that can be used. Nothing else can be created or innovated that can supplement that.
Because, again, to supplement her lordship's question, it appears to me that your company, your client, has been able to continue with innovation and has even considered coming up with cost-effective ride-hailing services that use advanced charging technologies that use 6G and 7G frequencies. So surely you can't say they have foreclosed them from the market.
My lords, we are trying to establish what is substantial foreclosure. And we don't want to be presumptuous about what entails innovation and how it can, long it can take to come up with a new innovation. And to that end, my lords, 8G is recent technology. It helps on the basic knowledge. It helps fast charging, efficiency, and cost effective as compared to these other networks that you have referred to, 6G and 7G, that are most definitely slower and more expensive.
Now, I like the fact that you use the word efficiency and then you referred us to these technologies. Please address this court on what you said you will be referring to European jurisdiction. Address this court on what the Court of Justice of the EU has said about the as efficient competitor test as being applicable when we are trying to determine whether a foreclosure is substantial, especially in the context of an exclusive agreement of this nature.
Your Lordships, in a peripheral of jurisprudence, the European Court of Justice has been of the opinion that on the as efficient computer test, that it is a test laid down to differentiate between what is uncompetitive behavior and what is squarely fair competition and protecting innovation. The Lordships will submit in the premises that we have to juxtapose the test against what we have submitted as the test advanced in La Roche versus the Commission, which amounts to substantial closure. That while determining whether it is actually anti-competitive or simply competition on the merits, we have to balance.
Exactly, and that's why I'm asking. You have in paragraph 4 a company, Green Drive, the respondent, coming up with a remote charging technology, that's SCC, the smart charging chip, right?
Yes.
This smart charging chip leverages 8G technology. no other company has come up with that level of efficiency, right? None of its competitors in the market, which existed at that time, had come up with that kind of technology at the time. So when we are trying to establish whether their foreclosure can be found to be anti-competitive, we have to question whether the competitors we are trying to protect, so to speak, were as efficient as to have leveraged this kind of technology. But we can see here that the only one efficient enough seems to have been Greenlight.
Much obliged to you, and I understand that argument. However, we submit that that argument must be counterfaced with other standards that have been set,
yes.
For example, to justify whether the foreclosure is indeed uncompetitive. Your Lordships directly...
And have courts made this, that as efficient test a merely directory test or as a mandatory test? You may want, when you're taking me to that direction that you're counter-balancing a test set by the courts, you have to establish whether it's a mandatory test or it's a directory test.
Your Lordships, it is a mandatory test. And while I juxtapose it on the communication of the Commission of the European Communities of 2009, which suggests that such agreements, even to leverage, for example, as you say, innovation, must be over defined time. In the facts, we have no duration of time that is defined. To that end, my lord, whether they have come up with an innovation or not, a perpetual agreement of the such seems to violate...
Are we not inferring the perpetual aspect from the facts in the same way we can't infer that it is of a limited time? I don't think we are comfortable also inferring that perpetual aspect from these facts, because it's paragraph 5 that tells us about the exclusivity agreement, but it doesn't seem to mention any timelines.
Exactly.
And I do not think that simply because the facts do not tell us the timelines, that connotes or denotes in any way perpetuality.
Exactly my point, my lord. That this is competition and governed by competition. That where a competitor and where this court holds the opinion that if this agreement is indeed perpetual, then it violates competition. Where the competitor enters and
let us assume that it isn't perpetual.
If it is not perpetual, my lords, then we will pursue other lines.
Please pursue those other lines.
Much obliged.
So that we do not come up with a moot judgment, an academic speculative judgment.
Indeed, my lords. My lords, I will now...
This educationist bench on the issue of under what circumstances do exclusive agreements serve as not being in violation with the competitive laws?
Your Lordships, much obliged for the question. To directly answer that question, I will seek this court to be persuaded by Article 101 of the Treaty of the Functioning of the European Community that sets out specifically under Clause 2 instances where exclusive agreements would seem not to violate the law and be uncompetitive. And it sets out clearly that they should be research-based, that they should foster competition, that they should be fostering innovation. We submit that this agreement is one that is against all laws. It does not support research as suggested in paragraph 3, where actually these companies come together once, not paragraph 3, my lords, look for that intelligence, that these companies come together, paragraph 8, my lords, these companies come together once a year annually to share information. It does not have such a link. It forecloses them competing from a relevant market that we have highlighted of the smart charging chips. So it violates all the requirements set out under Article 101, Clause 3 of the Treaty for the Functioning of the European Communities. And to that we submit that it cannot in any way be adjudicated over to constitute what is legally lawful. My lords, I will now submit on another basis that we submit that the dominant position was violated. And that basis is that Green Drive is leveraging power from one relevant market to another relevant market. They established that there is a relevant market of electric motor vehicles, but also there is a relevant market of smart charging chips. Now, this was the decision of the European Court of Justice, again, in Tetmark versus the Commission, where it held that where an entity uses its dominance in one relevant market to leverage dominance in another relevant market, then such an entity is violating its dominant position. To that end, Your Lordships, on these three thresholds and metrics,
develop that particular aspect. Don't leave it to us. I am interested in knowing how leveraging another dominant market is necessarily anti-competitive, since you are already a dominant player in another market.
Your Lordship, simply, I answer that question that when the rationale behind that jurisprudence, Your Lordships, is that when competitive entities already are dominant in one position and use the same dominance to leverage by foreclosing other entities from entering competition in an adjacent market. In this case, we have electric vehicles that must use wireless technological charging if innovation should take place. And therefore you leverage this dominance in electric vehicle manufacturing to smart charging chips. Then you're limiting your competitors from entering adjacent markets. And to that end, when you leverage power in that manner, it defeats the heart of competition, the heart of innovation. And to that end, then you violate your dominant position.
So is your point then that such companies should never come up with innovations? Because what if Green Drive just has a niche in developing, trendy technology and stuff?
Should it not get to benefit
from its innovations? Is that your point?
No.
Or it should take the lead, innovate, give others?
No, my Lord.
Is that what you're asking Green Drive to do?
Absolutely not, my Lord. My Lord, what I'm asking this court to do is that to hold Green Drive accountable, that even when they innovate and foster technology development, the benefits that they achieve should not be overly broad.
So how is it overly broad? How is it overly broad? When I get a particular component which I innovated without any other person having innovated that component, and I enter an exclusive agreement over a frequency which no one else was using at that point, no one else in my market was using at that point, how is that me being anti-competitive? I've entered a niche market as a fast mover, and I am trying to benefit from that by being a fast mover. So does it not defeat innovation, as you're suggesting, if you say I should invest in research and development, I should do all that, come up with a niche technology, then if I enter into an exclusivity agreement to protect that technology, I will be found anti-competitive?
To answer your question, my Lord, I invite this Honorable Court to apply the rule of reason and analysis, my Lord, which also, like I already
which
said,
denotes,
my Lord, that this court compares the pro-competitive benefit and the anti-competitive benefit at the end of the day. Lordships, we submit that when this exclusive agreement is upheld, then it forbids every other innovator from accessing 8G network. It, in other words, stifles innovation and stifles competition. There might be short-term benefits to an entity like Green Drive from benefiting from what it is innovated and being inspired. But at the end of the day, when you foreclose and demotivate all the other competitors against Green Drive,
so what incentive does Green Drive have to maybe work on a 9G technology, 10G at some point, if the moment it got 8G, someone told it, hey, no, don't make it exclusive. Exactly. Don't do anything about exclusivity. Because what you're asking us to hold is that exclusive agreements between dominant players are illegal per se. What have courts said about illegality per se of exclusivity agreements?
Your Lordships, I did not opine that they are illegal per se.
But the net effect of your argument seems to be taking us there, don't you think? And if it isn't, please show me an alternative way in which it could work without us making them illegal per se.
Yes, Your Lordships.
Or alternatively, could there be an authority that explains, justifies exactly that leveraging their position in this manner amounts to violation of competition laws?
Your Lordships, indeed, there is an authority, and I've cited Tatmark versus the Commission of the European Community, which is to the extent that leveraging power of a dominant position to an adjacent relevant market then violates the power. However, the Lordships, in my submission, I highlighted one important aspect, that there should have been, and I take cognizance of the kind of honor and prayer that you allow me 1 minute to close.
Go ahead.
Your Lordships, much obliged. That there should be the difference between substantial closure and other minor agreements that, and as co-counsel will highlight, that we term as de minimis, that which the law has termed as de minimis. These agreements do not necessarily substantially foreclose innovators from entering competition. We submit that Green Drive could have made such arguments to protect the 8G frequency, maybe for a limited time. There's a lot that it could have done, but not necessarily.
Sorry, Council, to interject you. Please distinguish the facts of the case you've just stated and compare it to the facts at hand in this case, so that we can borrow relief from it, so that we can judge that it is relevant. Because we have a feeling that...
So what are the facts of the case you've cited that make it particularly pertinent to this court?
Exactly.
Much obliged, Your Lordship.
Were they dealing with something similar?
Your Lordships, the case was not dealing with something similar, because in this case it was really about motorcycles, and the question was on parts of the motorcycles that were necessary for the technology of the motorcycle. And I have not read it at length, I only read the seminar. That were necessary for a motorcycle to operate and innovate increasingly. The Lordships, what we draw is not necessarily the conclusion of the court, because in that case, court...
I want you to maintain the relevance, that relevant part that you leveraging your dominant position in one relevant market to an adjacent market is problematic. So demonstrate to us what relevant market was moved into in that case. In the same way, show us what relevant market we're moving to in this case. That's really, just do a juxtaposition to answer.
And the Lordships, that's why I'm quick to say that I don't want to rely on the ultimate decision, because court was of the opinion that the relevant market was the same, there was no movement. However, it highlighted that if there were to be a movement from one market to another, then that would...
So show us in this case why smart charging chips, right, are a different relevant market from electronic vehicles.
To that end, Your Lordships, then I will rely on the jurisprudence of the European Court of Justice in United Brands versus the Commission while interpreting the banana code. Your Lordships, this is a case then that was discussing whether fresh fruit and bananas were the same relevant market. The European Court of Justice was of the opinion that when bananas have a substantial demand and more than any other fruit, then you can't construe them to constitute the same relevant market as the fruit. Lordships, we opine that in the circumstances, and I've established that Green Drive has dominance in both markets, but in the circumstances, electric motor vehicles can exist without a smart charging chip.
But in the same breath, when we look at the American jurisprudence, computer chips and computers together have been interpreted to be that the court has taken the view that both the chips and the computer are the relevant market because they are a component of the main product. So at that point, what is the more persuasive decision that you would want this court to consider when faced with those two decisions?
My Lordship, the premises, I invite this court to be persuaded by the decision of the European Court of Justice for one cause. That the true standard in the circumstances would be whether an electric motor vehicle can exist with any other charging technology save for the smart charging chip. And we are of the opinion that...
So basically saying that the US versus Microsoft Corporation case is distinguishable?
Yes, my lords.
Go ahead and distinguish.
My lords, I distinguish it on the basis that the microchips cannot be separated from computers.
But in this case, 8G technology is separable
from electric vehicles and the technology.
As demonstrated by what fact?
As demonstrated by your lordships, that simply from paragraph 7 of the facts, the joint venture is still accessing 7G and 8G frequencies to 7G and 8G frequencies to innovate other smart charging chips.
This time is up, right? Your time is up. Your time is up. Thank you very much. Please cede the floor to the...
Much obliged, your lordships. I cede the floor to co-counsel.
What report once again. My name is Marvin Sereko. I will be submitting on issues 2 and 3, respectively. On issue 2, as to whether the Equomotors and Solar Winds Collaborative Partnership, also known as the JV, has transformed into an anti-competitive cartel. My Lords, if I may invite this Honorable Court, paragraph 7 of the agreed facts, the Bukotos and Solar Winds joined hands and formed a joint venture. My Lords, relying on the decision of the House of Lords in its 2009 decision in Cowridge versus Graham, the court defined a joint venture to mean an enterprise subject to joint control by two or more undertakings which are economically independent of each other. My Lords, Bukotos and Solar Winds are economically independent of each other. They are two separate companies that are competing in the field of innovating electric motor vehicles. My Lords, on the other hand, a cartel is or was defined by the Supreme Court of the United States in the United States versus National Lead Corporation, a 2001 decision where the court defined a cartel to mean in its versatile form in the scope of business and competition, to mean an agreement of companies or sections of companies having common interests so as to prevent extreme or unfair competition in the market. My Lords, also citing the Treaty for the Functioning of the European Union as a persuasive instrument to this Honorable Court, Article 101 of this treaty regulates and prohibits agreements, decisions, and concerted practices which have an adverse effect to the market. My Lords, we submit that the joint venture between Bukotos and Solar Winds the joint venture between Bukotos and Solar Winds was simply a venture that they came into to innovate smart charging technologies and with an aim of coming up with a cost-effective ride-hailing business in the Republic of Uganda. My Lords, with that, we submit that there was no agreement, there was no decision, or there were no concerted practices, at least from the record of our facts.
Hold on a second. You said they entered a venture without engaging in concerted practices. What do you define as concerted practices?
My Lord, I beg your pardon.
I am mostly interested in how you conceptualize concerted practices in this context, because and maybe to guide a little. As far as I can tell, what is prohibited is not necessarily concerted practices, but concerted practices that have a particular effect. So is it your assertion in this case that there were no concerted practices, but there was a joint venture? Because that sounds like an oxymoron to me.
Thank you, my Lord, for that guidance. I will, I pray that this Honorable Court is persuaded and guided by the decision of the Supreme Court of the United States. My Lords, the decision in the United States versus the National Lead Corporation, as earlier on cited. This decision, the Supreme Court clearly establishes that it's in itself, the law in itself does not ban cartels, nor does it ban concerted practices, agreements, or decisions.
Yes.
However, it declares as illegal all agreements, decisions, and concerted practices that have a negative adverse effect on the competition.
So you see that's why I want us to go exactly where we're supposed to be, as opposed to, because when you make the suggestion that somehow there was a joint venture but there was no agreement, there were no concerted practices, I think the aspect you want to be telling us about is negative adverse consequences. Because when you say no agreement, it can't be a joint venture when there's no agreement. The concerted practice can't be a joint venture without concerted practices. All those things have to be in place. The question is on negative adverse effect. Please address us on that.
Thank you very much, my Lord, for that guidance. With that, my Lord, the applicant submits that there is no evidence in the fact that the joint venture between Bukotos and Solar Winds had a negative adverse effect.
Which are defined as what, for instance?
The negative adverse effects have been defined by different jurisprudences. However, I'm going to rely on the instrument of the functioning of the European communities.
Called the treaty.
The Treaty for the Functioning of the European Communities, which defines, establishes and defines acts that are prohibited under competition law. These acts include price fixing, bid rigging, sharing of the market, and among others.
Now let's bring it to the facts, yes? Let's bring it to the facts. In the facts, when we go to paragraph 13, yes, 13, some of the things that the work found you culpable of or potentially culpable of was sharing sensitive business details and pricing strategies. What do you consider to be a pricing strategy, and what is the net effect of exchanging pricing strategy?
Much obliged, my lords. My lords, the problem is not coming up with a pricing strategy. Neither is the problem.
No, it's not coming up with it. It is exchanging pricing strategies when you are competitors, potential competitors. Now you're sharing pricing strategies which may potentially allow you to fix prices, which you agree is an anti-competitive.
Much obliged, my lord. As earlier on established, we have agreed that concerted practices like those in themselves are not the problem. However, we look at the effect of such practices.
Now, when we go to the ESC Competition Act, right? What we see from Section 6 seems to suggest otherwise, that actually among the exemptions to the exemptions is pricing information. Sharing of pricing information, even when we're dealing with collaborative research, which I believe you're going to address me in your next issue, it's explicitly prohibited for you to be exchanging pricing information. So what justification could you possibly advance for this court?
Now, in an attempt to answer your question, my lord, pricing or fixing of prices in itself, the threshold set there is the effect of such an act on the consumer value and the market at large. My lord, there is no evidence that the joint venture and sharing of this information in the same business or in the same room of innovation has any negative adverse effect to the market and to the competition at large. As earlier on established by lead counsel, that we have two markets at stake. We have the market of the electric motor vehicles and we have the market of the smart charging chips. Now, my lord, the market that we have the joint venture in is a market for more innovations on electric vehicles with an aim of coming up with a cost-effective ride-hailing services. My lord, to put in context, a cost-effective service hailing ride is equivalent to what we have like Ubers, Safe Cars, and Lyft. Now, my lord, to come up with a program like that or an innovation like that was not in Wakanda, in itself, I think we should applaud the joint venture for coming up with such an innovation. In that, my lord, we submit that the joint venture itself did not constitute an anti-competitive behavior, and as such, sharing pertinent information in that field was only enabling these companies to relate to the information and ideas and build on that to come up with a consumer valuable-based innovation that we would applaud in the Republic of Wakanda. As such, we submit that this innovation did not violate any laws.
Council, I'm going to take you back again. The ESC Competition Act, when it is making allowance for the leveraging of the test you're setting out for me, that if the effect is not adverse on competition, we can allow for certain potentially anti-competitive behavior, right? It specifies that when it is one of the things listed in section 5.2 above, those things are not permissible even in those circumstances. Don't you? And one of those things is price fixing. Don't you think then it becomes a problem for me to say price fixing is among the things that are okay, even if even if the effect is adverse? Or could you maybe point us to a different interpretation of those sections?
If I may invite this Honorable Court to be persuaded by the decision of the European Court of Justice in the decision of the Roche of 1986. Clearly the court distinguished on the effect of such practices. My Lord, clearly looking at the effect that you just asked me, this court can distinguish the effect that will come from such an innovation of price fixing and the threshold.
Actually, what I'm saying is that the net effect of Section 6, read to the extent that Section 6, I think 4, is that it makes price fixing and the things listed under Section 5.2 of the ESC Competition Act illegal per se. And what that means is that there is no room for us to say, let's look into the effect. I don't know if you're getting my point. So the question is, how are you going to navigate that illegality per se?
Much obliged, my Lord. My Lord, that section is not casted in iron and stone. And the exceptions thereon are very clear that the threshold that courts have applied in that section are that what is the advantage that we are getting from such a joint venture vis-a-vis the disadvantage that we are getting from that venture.
What is the nature of the wording that's used in Section 5, subsection 2? A person shall not.
Shall not.
How have courts in Wakanda interpreted the use of the word shall?
My Lord, much obliged for that guidance. My Lord, it is settled law that provisions of the statutes must be given their construed meaning, must be given their construed meaning.
And the word shall, has been construed to mean what?
The word shall has been construed to mean a mandatory requirement.
Exactly.
However, my Lord, the courts are also alive to the fact that recourse shall always be put to the intention of the draftsman vis-a-vis the effect of such legislation to the community. My Lord, such an innovation, if
the clear intent of the draftsman of the ESC Competition Act was to prohibit, to make illegal per se, acts including price fixing, how could you be telling us, how do you justify telling this court that let's first go and see whether the price fixing had a negative effect on competition? And perhaps to go into legislative intent, the legislative intent that underlies things like prohibiting price fixing per se is that these typically, when you look at economic policy, these typically will affect competition by mere virtue of the fact that two players that should be setting prices and allowing the market forces to dictate are now exchanging information on how to set the price, thereby prejudicing others that do not have access to the same information.
Thank you very much,
And it seems to us that that is what your clients were doing, which is the behavior that they are accusing. The work seems to suggest is potentially anti-competitive.
Thank you very much, my Lord. The doctrine of equity is that he who comes to equity must come with clean hands. The applicants resorted to a joint venture with an aim of joining hands, due to the dominant violations from the respondents. My Lord, in any case, the facts clearly state that they came up with strategies of fixing prices, but they did not fix prices in themselves. So we cannot hold them liable for something that they have not yet done. With that, my Lord, I pray that this honorable court finds that in any case, if there was a cartel, this cartel did not constitute to an anti-competitive cartel because it does not engage in anti-competitive behaviors as stipulated under the Treaty for the Function of the European Union and the Competition Bill of 2020.
So if your argument is that your potentially what work found as potentially anti-competitive behavior under paragraph 14 is that it was a response to the abuse of dominant position by the applicant. How does that fit within your suggestion that you must come with clean hands? It seems to me that you're saying these people did anti-competitive stuff. Let me also do anti-competitive stuff.
It came out of what we call the commercial competing necessity. When you put the applicants and the respondents in the same position, we realize that one of them is having a greater hand, and they are competing in the same market.
Perhaps what this court is interested in seeing is why should there be, like, why should this court look lightly upon your violation, even if we were to say there is a violation this side?
My Lord.
And besides, in relation to the same question, if you've well appreciated their competitive law, at least it has given objective justification, right, for whatever action, so that way it could be precluded from failing to, from not violating the law, right? I'm not seeing it anywhere from your submission that what was done could be a defense. Besides, if it happens to be a defense, don't you think it's just your opinion, not submitting from the law and the facts?
So glad, my Lord. Thank you for that indulgence. I will ask this honorable, I will say that this honorable court is persuaded by the decision of the European Court of Justice in Majil TV Guide versus the Commission of the European Communities. My Lord, in this case, the court clearly held that where acts of the applicant were out of the commercial necessity to compete, such acts did not equate to cartel conduct and therefore were not a violation of the competition laws. My Lord, my time is fast spent. I pray that I proceed on with the merits of issue 3 and consequently make the prayers of the applicants.
My Lord, I'm just requesting for one response from you. Is it okay?
Yeah.
Please, educate the bench on the objective justifications for you, what the law provides as exceptions, and which one can as well go ahead and violate
My Lord,
competition laws.
I do not have the shoes, or I do not sit that high to educate this bench. However, my humble opinion
Basically, that would give you some leave to engage in potentially anti-competitive behavior and get away with it.
My Lord, we relied on Clause 8 of the Competition Bill of 2022, specifically Clause 8, Subclause 3, which provides for the exceptions of concerted practices like the ones we have in our facts. My Lord, with that, the bill suggests that if those practices are intended to benefit the public at large and they are not private benefits, then the law shall be limited on such concerted practices. With that, I pray that the Honorable Court is persuaded by the provisions of the competition bill, specifically under Clause 8, Subclause 3. My Lord, I will summarize my arguments on issue 3 and consequently make the prayers of the applicants. My Lord, the question before this Honorable Court is whether the collaborative research and development efforts between Ecomotors and Solar Wheels constitute legitimate technological innovations. My Lords, according to the European Union guidelines on horizontal cooperative agreements of 16th July 2023, defines collaborative research and development as a partnership between two or more parties who work together to achieve a common goal. My Lords, collaborative research comes with sharing of information, ideas, and enabling participants to learn from each other and build from each other's ideas. My Lords, with that, I call upon the Honorable Court to rely on paragraph 7 of our facts, where these two Ecomotors and Solar Wheels entered into a collaborative research to foster their innovations. My Lords, the applicants submit that the research and development efforts between Solar Wheels and Ecomotors did not constitute to illegitimate technological innovations.
What is a technological innovation?
Thank you very much, my Lord. My Lord, a technological innovation is simply an innovation, or it's simply a creation, a new creation that comes out of the technological field or the technological world.
What is the authority for that?
My authority, my lord, that I'm not an authority, but with leave of court, I will submit my authority to this honorable court. That is just how I understand technological innovation. Therefore, my lord, this collaborative research and development was based and aimed at improving the charging solutions for electric vehicles, which was a new and dynamic technology. My lord, time is fast spent. I pray that this honorable court awards me 1 minute to conclude with my argument and subsequently make our prayers.
Go ahead. Very good.
Much obliged, my lord. With that, we submit, my lord, that the intention of the collaborative research was to innovate new technologies in the charging field and subsequently come up with a new innovation of cost-effective ride-hailing services business in the Republic of Uganda. My lords, that is pursuant to paragraph 8 of the above facts. With that, we submit, my lords, that there is no evidence in the facts that this collaborative research was illegitimate and as such had a negative adverse effect.
I think you may want to actually just oppose paragraph 8 with paragraph 14 and give us your justification in that context, because if you do not address it, it is simply you cherry picking our facts to look at why it remains legitimate and ignore other parts that would make it illegitimate.
My lord, the findings of work are not in themselves conclusive, and that's why we're before this honorable court to determine as to whether these findings are really
so why do you think work's findings, why should we find work's findings that you were out of scope of the collaboration, one, wrong, and that there was potentially anti-competitive behavior, wrong?
I should like my lord,
Demonstrate to us.
Being the existence of potential anti-competitive behaviors do not in themselves mean that there was an anti-competitive behavior. And with such, we submit that the collaboration or the collaborative research and development had more positive effects to the
who has the duty? Who has the burden? Who has the burden to demonstrate that behavior is anti-competitive? What have the courts said on the burden to demonstrate that behavior is competitive or anti-competitive?
My lord, the general principle of law is that the person that asserts or the person that intends court to rely on their assertions should prove those assertions. And in this case, the respondents maybe will come and prove to this honorable court that there was anti-competitive behavior from the collaborative research and development.
Okay, how about the aspect of exceeding the scope of your collaboration? Address that too.
Much obliged, my lord. My lord, exceeding the scope of collaboration is not the problem. The problem is...
It is not the problem.
My lord, in this case, exceeding the scope of collaboration might have been a leakage in their collaborative development and research project. However, in itself, it has not come up with any negative adverse effects to the competition and in the market. My lord, what we pray that this honorable court determine today is whether the collaborative research
so I think here's where you're taking us in circles. One, you seem to be of the view that we can ignore your exceeding of the scope of your collaborative agreement. You also think we can ignore the fact that you engaged in exchange of pricing strategies, potentially engaging in price fixing, which, as we have seen, is considered illegal per se under Section 6 of the ESC Competition Act. Don't you think that's like such a huge conglomeration of red flags that it may be difficult for us to find in your favor on this issue?
My lord, courts have over time come up with the test of the effects balancing test. My lords, I feel that this honorable court is also inclined to apply that test. What are the
if the effect of your joint venture, if the effect of your joint venture and the collaborative research that it has done is that you're going to fix prices, you're going to exchange customer data, you're going to do all those things, don't you think that that is exactly why this court is supposed to put a stop to that kind of thing?
My lord, as earlier on established, that law is not cast in iron and stone. There are exceptions that my lord, the exceptions are that where such innovations are for the benefit of the public. My lord, sharing customer data when we are in the same business has never been a problem. In fact, there is no law that bars sharing market data where the parties are in the same business. The problem
even the Data Protection and Privacy Act does not prohibit sharing of data between businesses.
Much obliged, my lord. My lord, the data
I can collect data as Cavendish University and share it with Makerere University because we are all in the education sector.
Much obliged, my lord. My lord, if this honorable court is inclined...
Even if we were doing a joint venture, let's say to do a course on mooting.
Much obliged. My lord, if this honorable court is inclined to agree that indeed there was a breach of data protection regulations, we pray to this honorable court to apply the effects balancing test.
But you're not showing me any good effects. That's the challenge.
My lord, I've established the effects and I can re-echo them to this honorable court that the smart charging innovations that the joint venture have come up with are going to not only help the private consumers of this product, but the whole public that has purchased electric motor vehicles to charge remotely. Because now, my lords, what we have established before this honorable court is that even when there is a dominant party that has entered an exclusive agreement with the only entity that licenses 8G frequencies, these companies have not gone back home to sleep. These companies have looked for alternative measures or means to come up with intermittent.
So regardless of whether you're abusing laws, breaching data privacy,
provided the two of you, provided you're fighting a fellow big company which is violating competition law,
my lords, innovation like any other new thing or novelty, you cannot get it right at the first time. So innovation comes with amendments.
So is that a concession? What is that?
Make it clear for us.
My lord, this is a fact.
If you are conceding that you violated some anti-competitive behavior for the greater good, you can also tell us.
No, my lord,
and at the same time, it appears as if you're contradicting your the applicant's first submission, because you were claiming that these people infringed on your right? Much as they are also claiming that this, because they're innovative technology, they have a right to do whatever is possible as long as it's not going to be detrimental to the consumer. You said no. The fact that we have a license, we have that exclusive mandate to deliver this. So if they did otherwise, they're infringing. Now this time you're saying as long as
the negative effects are not that much. You started by saying as long as there are no negative effects. Then you went on to say the negative effects shouldn't be that adverse. At some point you may say, let's just leave competition law alone.
My lords, the submission of the applicants is clear that there was no anti-competitive behavior from the applicants, both from the joint venture, Eco-Motors and Solar Wheels. And in any case, if this honorable court finds that there was a cartel, that cartel, in case this honorable court is inclined to find that the collaborative research transformed into illegitimate technological innovations, it is still our submission that those innovations cannot be taken as cartelling factors in this field of innovations. And therefore, this honorable court finds that, one, Green Drive did not have a dominant position. Green Drive had a dominant position, and that two, the joint venture or the collaborative partnership between Eco-Motors and Solar Wheels did not constitute into an anti-competitive cartel. And three, that the collaborative research and development did not transform into illegitimate technological innovations. My lords, we pray that the applicants rest their case.
Respondents.
For purposes of court record, as I introduced by last major, my name is Mirabelinda. Kamdema, and I'm appearing on behalf of the respondents. I will be addressing you, my lords, on issues 1 and 2, where I'll be establishing that the exclusive agreement between Green Drive and Sky Connect did not constitute an abuse of dominant position. My lords, the respondent involved all their energy and the resources they had to develop smart charging chips that could access or intercept 8G ultra-high frequencies. However, right now we're being punished for our own innovations and the applicant alleging that we abused our dominant position by undertaking an exclusive agreement. However, respondent is before this honorable court to try and clear the air first of all. And I will be addressing this issue by dissecting it and addressing this issue under two head arguments. One, that Green Drive was not in a dominant position. And two, that in the alternative, there was no abuse of that dominant position. Proceeding to the first limb of argument that Green Drive was not in a dominant position. Applicant earlier asserted that, and relying on paragraph 3 of the statement of facts, that Green Drive was in a dominant position basing on the market share and the statement that it was the leading manufacturer. It is true, and the applicants, the respondents submit, that it is true market share is a determinant in determining whether an undertaking occupies a dominant position. Before I continue, let me first define what a dominant position is before this honorable court. A dominant position was defined under Section 2 of the East African Community Competition Act to mean a position of economic strength enjoyed by one or more undertakings, which enables this undertaking to act independently of its competitors. It was stated, my lords, in the case of USA versus Microsoft Corporation, a case of 2003 before the Appellate Court of the United States, that yes, the market share is necessary to determine the dominant position of an undertaking. However, it is not sufficient, as other factors have to be given due consideration. Amongst those factors include, my lords, 1, ability to act independently of competitive forces, and 2, the dependency of consumers on enterprise. I'll begin with ability to act independently of the competitive forces. In the case Vishambwa, M. and Vandafani India Limited, case number 4 of 2016, it was stated that for an undertaking...
Excuse me, counsel. Is that source of authority binding on this court or persuasive?
Much obliged, my lord. This source is of a persuasive nature before this honorable court. It was stated in this case that for an undertaking to act independently, it should have acquired a position of economic strength as compared to its competitors. It was also stated in the guidance on Article 102 enforcement priorities in applying Article 82 of the EC Treaty to abusive extortionary conduct by dominant undertakings that existence of strong competition in the market negates or permits the Commission to hold that there was no dominancy in the market. Pursuant to the facts, my lords, if you'd be kind enough to please turn to page 1, paragraph 7. It is indicated that other prominent electrical vehicle manufacturers in Uganda include Eco Motors and Solar Winds. These two companies posed effective competition against Green Drive.
Counsel, I think now you're trying to redefine competition law, because is your position that dominant position cannot, a company cannot have dominant position in a market where there are prominent players? Simply put, Coca-Cola cannot have a dominant position in a market where there is rehab.
Much obliged, my lord. In response to your question, they could have a dominant position.
Because you define for us, let's look at your definition that you read for us of dominant position.
Yes, my lord.
Position of economic strength, I believe that part is met, right?
Yes, my lord.
Enjoyed by one undertaking individually, this is Green Drive, right?
Yes, my lord.
Or by more undertakings collectively, which enables them, this is we're talking about Green Drive and Sky Connect, enables them to prevent effective competition being maintained in the relevant market by giving the undertaking or undertakings the power to behave to a material extent independently of its or their competitors, customers, or consumers, and in particular to foreclose other undertakings. As explained by the applicants, the relevant market we're discussing is a market for smart charging chips, components that are necessary for the functioning of the electronic vehicles that we're dealing with. Also relevant is the fact that you entered into an exclusive agreement that you're trying to address this court about. The net effect of that exclusive agreement is to say no one else but Green Drive can access 8G UHF, and therefore by extension can use the 8G UHF smart charging component. So I'm curious to know how that does not constitute a dominant position, because remember here what we're addressing is not yet even abuse. We're addressing your point on that there is no dominant position whatsoever. When you're done with that, I want you to take us specifically to the provisions of, I think it's clause 8 of the competition bill, which is persuasive only for its persuasive value before this court, and tell us which parts, which aspects of dominant position that are defined there are not met by Green Drive.
Much obliged, my God. In response to your earlier question of them us undertaking an exclusive agreement amounting to an abuse of the dominant position. However, it was my earlier submission that we were not in a dominant position, and I was still establishing why we were not in that dominant position.
Yes.
Reason being, there was effective competition in the market, which could negate existence of dominance. Secondly, was dependence of consumers on enterprise. Given the fact that there was a variety of consumer choice in Uganda, it couldn't be concluded that there was dominancy by Green Drive.
What was the consumer choice in Wakanda in this regard? For instance, strictly to the JV? Yes, the party who were interested.
They wanted 8G UHF.
So now at this point, it is
they are the consumer.
That was now the product. What was the alternative in this case?
What could the consumer do? They tried, paragraph 9 said they tried to approach you for licenses and they couldn't get them.
It is true, my lord, that we couldn't give them this license, but given the fact that Green Drive had just developed the smart charging chips that intercept the 8G, it was going to be against, it was going to be an infringement on patent.
Counsel, please don't mislead court. The point is, from your point of submission, you're claiming that you're not a dominant party on the fact that the other part had an alternative.
Yeah, they had an alternative. There was consumer choice. We are interested in knowing what consumer choice there was. Yet, meanwhile, you are alive that under this issue you're also representing Sky Connect, you're also representing the Attorney General, you're also representing Green Drive. So collectively, your parties looked on while one party, which because you're telling me Green Drive came up with an innovation, but Sky Connect was the only supplier. They tell us in paragraph 5, exclusive supplier of 8G. This was not Green Drive's innovation. It's just that they entered into an agreement that had the effect of locking or foreclosing a source of supply to other people. The only reason you are able to do that is because you are an exclusive producer of chips, they are an exclusive producer of supplier of 8G UHF. Now, the question is, how is that not a dominant position? Because we will get to the part where you tell us how that's not abusing the dominant position. But how is a company in position to do that, not in a dominant position?
I'm much obliged, my lord. In relation to consumer choice, and first, the development of antitrust laws is one, to promote fair competition amongst the competitors, hence protecting the infringement of rights of consumers. In this case, what we're looking at is the development. Green Drive manufactured smart charging chips. Likewise, the applicants, that is the JV, they had their chip that could access 6G and 7G. Given the
So
fact
8G was not a green drive innovation. They only innovated to tap into 8G. You noted that little fact. So they basically were saying no one else should innovate to tap into 8G. How is that not someone being able to foreclose? How is that not foreclosing competition?
much obliged, my lord. The fact that in order to access that license, in order to access that network, the 8G, you had to obtain a license. Them as
A license from whom?
From SkyConnect.
Uh-huh.
As the Green Drive accessing this network and signing an exclusive agreement did not amount to an abuse of that position. Yes, we recognize the fact that we had a significant market share in the market. However, other factors had to be considered in order to determine that we're in a dominant position. Applicants submit that we used the exclusive agreement to abuse that dominant position. As I've earlier established, we're not in a dominant position.
No, you have not yet established it. You have not yet established it. We are actually waiting for you to establish it.
I've established that, one, for...
Because let me remind you of what you told us. You said there was consumer choice. We asked you what was the choice. There was only one. Paragraph says, Wakanda, that SkyConnect is a major telecommunications network provider in Wakanda that exclusively offers 8G frequency network licenses. That means they couldn't get them from anyone else. In fact, SkyConnect, which is one of your clients, already is in a dominant position. But we're trying to establish whether it is Green Drive that violated its dominant position. What they have submitted is that you leveraged your position as Green Drive, your dominant position as Green Drive, as a leading manufacturer. You've been leading manufacturer of electric vehicles, to an adjacent relevant market, which is of 8G frequency network licenses, and foreclosed other people from that market. So you notice that there's a clear stream, and I don't think you have been able to punch any holes in that stream. I am interested in you punching those holes in that stream. When you say consumer choice, I am hard-pressed, and I think her lordship was hard-pressed to see what consumer choice did they have.
My lord, in regards to consumer choice, I'm not referring to JV or Ecomotors and Green Drive in this matter. I'm referring to the third-party consumers in the Ugandan market.
But that's not the relevant market that we're speaking about. What they have, the position they have established. So the relevant market is the market for 8G supported smart charging chips. You are the position that they established was that the anti-competitive behavior you're engaging in is making it impossible for the JV to support its smart charging chips with 8G. So I'm not getting this from my own head. These are the arguments of the applicants. So I'm interested in your actual direct response to that.
Much obliged, my lord. As I earlier stated, Green Drive was not in a dominant position. Reason being, they couldn't act independently of their of competing forces. Secondly, the consumer choice.
I think let's just agree to disagree that
on
yes,
dominant
on
position.
dominant
Try to
position.
argue on
Try,
abuse,
yes.
but I do not think you have much of a chance as far as its dominant position goes.
Much obliged, my lord.
Actually, in the case law has showed it, I thought you're going to also refer to this case, where it is crystal clear that for a party or a firm to challenge its dominancy, for instance, under pricing, if it happens that the trend shows that it is not, there are so many prices, or else it is in a dominant position, but prices are being, their prices are being fixed beyond their control. So there is varying price discrimination, varying prices, no matter being a dominant position. That alone is an example for a defense, for one to say that much as I could be having a big market share, but the fact that I'm not determining the prices, that can exclude me from being a dominant position. But from the facts at hand, which you've read for us, that different paragraphs are really showing that you have a significant share. You're controlling most of the products at hand. So how do you convince this court that really you're not a dominant?
And because your time is really fast spent, you may want to move to abuse. Address us on how, now that we think you have a dominant market position, address us on that, what you said was your alternative argument, which I think now should be your primary argument as to why you could not possibly have abused this dominant market by entering into an exclusive distribution agreement.
Much obliged, my lord. Given the fact that in the event that this honorable court finds that we're in a dominant position, would further state as respondents that it is not an offense to hold the dominant position.
Yes.
However, assert that there was no abuse by the undertaking, as alleged by the applicant that we undertook an exclusive agreement. It is indicated under the case of US EMA versus Microsoft that if an undertaking can come across an abuse of its dominant position if it undertakes an exclusive agreement, which agreement in the long run affects trade. It was also stated in the case of Srini Raj versus Malhotra Advocates versus North Delhi, where it was stated by the Competition Commission of India that for an exclusive agreement to constitute an abuse, it should be able to drive existing competitors out of the market, foreclosure of competition, and 3, create barriers to new entrants in the market. My lord, the applicants earlier alleged that with the agreement, we created a barrier whereby they couldn't access the resources, that is AG, hence abusing our dominant position. However, it is our argument that it didn't constitute an abuse, given the fact that if you'd be kind enough to proceed to the statement of facts, under paragraph 10, it was indicated that when after JV sought to obtain licenses, which request was denied by Sky Connect, they went ahead and paragraph.
On the premise of the exclusive distribution agreement, please don't omit that.
Much obliged. On their request was denied by Sky Connect, citing the exclusive agreement. However, it is indicated under paragraph 10, my lords, that in response, JV went ahead and developed electrical vehicles that have these chips that could intermittently access AG. They are saying that we created a barrier for them to enter into the market.
What was your response to them creating that? What was your response when they created SCC-enabled technology that could intermittently access 8G UHF signals for remote charging? What did you do when they managed of their own volition, out of their own innovation to do it? How did you respond?
Actually, before the way you responded, what were you responding to?
Much obliged, my lord. When Green Drive discovered that there was a similarity between the chips of JV and the ones that they had, they conducted an investigation into this matter.
Counsel, no. You're misleading court. The facts are showing that when they requested for a license from Sky Connect, right? Sky Connect declined on the ground that it had an exclusive agreement. So they could not offer the license. Yes. So it was in response of this that they did otherwise. And so when they did what they did, what was your response? It's what he wants. You can see how it's a chronological flow of events.
What happened when you discovered that they could intermittently access 8G UHF?
Much obliged, my lord. That is what I was submitting on exactly. As indicated under paragraph 11, that when Green Drive came to know that there was a similarity between the chips that JV was using and those of Green Drive, it initiated a private investigation and later on even contacted WAC as indicated under paragraph 12. WAC then later on initiated an investigation which found that
you filed a complaint. So basically you entered in an agreement that doesn't allow them to access 8G UHF, right? When they figured out a way to access 8G UHF intermittently, you complained, you filed a complaint against them. Now, tell me how that does not fit within the definition of a a vertical distribution agreement contrary to that is prohibited under the ESC Competition Act, particularly section 10.
Much obliged, my lord. Even with the non-existence of the exclusive agreement, it is not a mandate that Sky Connect was supposed to offer a license to JV in order to access that network, even in the absence of that agreement. It was in the sole discretion of Sky Connect to either offer a license or not, which in this case...
You keep forgetting that Sky Connect is also before this court as a party. I think you are under the mistaken hope that you can throw Sky Connect under the bus and get away with it as Green Drive, which won't happen. One of the parties you're representing under issue 1 is Sky Connect. So whenever you want to consider throwing it under the bus, think twice. It's also your client.
And then you're also running away from your very facts. Sky Connect, your client,
cited the exclusive distribution agreement for it to refuse this license. So you cannot say in the absence of the exclusive distribution agreement, it could have refused to give this whatever. So there you're taking us down the path of the hypothetical.
Much obliged, my lord. It is true that the exclusive agreement existed, and we don't refute that fact. However, I was just giving an inference. Let's say the situation was different. I'm not trying to
Let's first deal with the situation that is here. You know,
Yes.
The reason why I want you to deal with the situation that is here is, actually, let me simplify my question. What is a vertical distribution agreement? Are they prohibited? Did your exclusive distribution agreement amount or have the effect of a vertical distribution agreement?
Much obliged, my lord. Yes, indeed, vertical agreements are prohibited.
Vertical
However,
distribution agreement.
I beg your pardon. They are prohibited. However, our agreement, the exclusive agreement, doesn't fall under this ambit.
Okay.
Because
so let's go and look at that ambit that you're speaking about. It is defined under section 10 of the ESC Competition Act, right? So let's go there together. An undertaking holding a dominant position in the relevant market shall not engage in a practice whereby A, the resale prices or conditions are directly or indirectly fixed, right? That's one. 2, customers or competitors are foreclosed from access to sources of supply or from access to outlets. And C, movement of goods or services between different geographical areas are restricted. D, an intellectual property right is used in any way that goes beyond the limits of its legal protection. And 2, any person who contravenes this section commits an offense. It's an offense for you to enter into an agreement that forecloses customers from or competitors from from access to supply or from access to outlets. The supply in this case is AGUSF, which is exclusively supplied by the second respondent, or the third respondent in this case, Sky Connect. You foreclosed access from them. How is that not a vertical distribution agreement? And if it is a vertical distribution agreement, isn't that committing an offense? I'm giving you 1 minute to answer that question.
much obliged, my lord. If I would persuade you with a case of Jefferson, Parish Hospital District Number 2 versus Heidi in the US, a case of 1984, it was stated that in the case that an exclusive agreement did not make an exclusive agreement does not make the contract illegal, because only if it is time bound, and 2, if it expressly states what parties are excluded by the agreement. Pursuant to the facts we have at hand, my lords, under paragraph 5, it is simply indicated that Green Drive has entered into an exclusive agreement with Sky Connect. It doesn't fall under the ambit of an exclusive agreement per se, given the fact that it isn't time bound. For an exclusive agreement to be valid, it must have a time bound that,
I think we established with the applicants that we are only drawing inferences and we're going into the realm of speculations when we say it's either time bound or not time bound. There is no part in the facts where we can draw that inference, and I prefer that we don't go there.
much obliged, my lord. The fact still remains that the exclusive agreement that we signed, that we entered into with Sky Connect, did not constitute an abuse of our dominant position, given the fact that under the case I earlier stated that under the case of Shirin Raj, for an exclusive agreement to amount to an abuse, it should, 1, drive existing...
I think the case you cited took the position that exclusive agreements in distribution network are not illegal per se. A court is bound to examine the circumstances of what are they called? The practices, the alleged infringing practices. In this case, we have examined the infringing practices, and we're saying the infringing practice, the alleged infringing practice, is the foreclosing of access to a particular crucial component of the functioning of a market. You're making it impossible for the competitors to play or to access a certain crucial component or aspect of their market. I'm asking, how can you possibly avoid that being construed as a vertical distribution agreement, thereby making it anti-competitive?
Much obliged, my lord. You earlier stated that with the exclusive agreement, we made it impossible for the JV to access the 8G network. However, how do we later explain that they later on access this network? I couldn't say that.
The reason why WAC fined them, the reason why WAC was able to say that they actually operated without licenses is because it is true indeed that the exclusive supplier of 8G didn't give them licenses, but somehow they accessed 8G, thereby breaching licenses. Meaning that even if they could figure out a way of accessing it without coming directly to you, it would be illegal because there is a license holder. And you have leveraged that market and engaged in an agreement that says no one else should actually get onto this network. Think about it this way. There is broadband. And let's say you go to the UCC and say, from frequencies 100 to 220, I am the exclusive supplier of this, whatever, they should only be given to me. Someone comes up with something that needs, you're in a business where that frequency is necessary for them to operate, but you have taken it out of play. How is that not being anti-competitive, right? One dominant player, let's say Vision Group, comes in and gets all frequencies from, like, say, 100 to 300. How does it not prejudice competition by foreclosing them? I'm trying to put it in, like, simpler terms, radio frequencies that we are more used to. Do you see the corollary? So how do you explain that that is not an abuse of dominant position? And especially if the reason why Vision Group is able to do that is because it is it's a dominant player which has connections with UCC, which gives out these frequencies.
My lord, respondent wouldn't put it to the fact that and state that the reason as to why we signed this exclusive agreement with Sky Connect was because we were closer and we had this dominant position. It is not because of that dominant position that we undertook this exclusive agreement. This exclusive agreement was to help us enjoy our innovation that we had developed. Our smart charging chips that we had developed to access the 8G that is provided by Sky Connect. Undertaking this exclusive agreement was to give us the time to enjoy until other people innovate and come up and then access this network.
And when they did innovate, you reported them and said, please stop this.
And by the time we took this exclusive agreement, no one else in Wakanda was using 8G. The JV was using only 6G and 7G. There was no other company in Wakanda that was using the 8G by the time we took the exclusive agreement.
So doesn't that mean that that was the intention? To give you an opportunity to enjoy your ingenuity?
Yeah, and more importantly, I mean, what do you understand by the part of Section 10 of the ESC Competition Act that says using your intellectual property beyond its described limits? What do you think that was meant to prevent against? Because the intellectual property that you're referring as to is probably your patent and your industrial design. They addressed them. The question is, they were not coming after your industrial design that enabled you to make 8G frequencies. In fact, they probably came up with their own kind of smart charging chip, because indeed they had other smart charging chips. So it was within the scope of their innovation. Your specific innovation, what you had an industrial design over probably was the smart charging chip that enabled access to 8G. So the question becomes, at what point does it cease to be simply protecting your intellectual property and become, let other people never have something that is even remotely within this area? Because you have a smart charging chip, but you're saying now people should never exceed 8G, 7G if they are going to work on smart charging chips. Don't you think that's problematic? And that's very detrimental to innovation.
Much obliged, my lord. As I earlier stated, an exclusive agreement must be time-bound. You earlier indicated that the mere fact that this problem doesn't state that there was an exclusive agreement means that all these elements were fulfilled. So it is safe to say, my lords, that this enjoyment of this right or this innovation was to come to an end at a certain time, given the fact that they had signed an exclusive agreement that was going to take a certain period of time and then lapse. They were going to enjoy their also 8G at a given time. Later in the day, when they become, they were going to enjoy the 8G network at any point in time.
And that, throughout that whole period, consumers are foreclosed from accessing that product from anyone but you. You are forking in profits that no one else is able to leverage. All the while, this is a product that is on the market. You're forcing people to figure out, this is a country that is suffering with environmental pollution. You want them to go and manufacture new components that somehow are less efficient, and how do we justify that as a court that is meant to, uphold justice? How do we justify that?
Much obliged, my lord.
And I think her time is fast spent, right?
Yes, yes. But just answer his question.
Answer that question and please cede to the next party.
Much obliged, my lord. In response, you've earlier stated that there was indeed environmental pollution. And given the fact that Green Drive had developed these new smart charging chips, so meaning that this was a new product on market, them undertaking an exclusive agreement in order to bring a new product on market, it has to first be tested to see if it is consumer friendly or even effective in that matter. The reason in shifting to electrical vehicles is to limit fossil fuels and gas emissions, that is, reducing pollution. Us undertaking, the respondent undertaking an exclusive agreement was to give them ample time to test their innovation to see if it is environmental friendly or even consumer friendly, my lord.
Answer. Those are the facts of the case, or you are just giving your opinion?
My lord, it is not my opinion, and it is not in the facts, but it can be inferred from the facts in this case.
I think finance is problematic, but because of your time, we're going to
Yeah.
probably address those questions to your colleague.
Much obliged, my lord.
Thank you, Counsel.
I call upon my co-counsel to address you on issue 3, as well as make the respondents' prayers.
May it please this court, as I earlier introduced myself, my name is Katonda Chikau, appearing on behalf of the respondents, and I shall be submitting in response to the applicant's submissions on issue 3, which states that whether the collaborative research and development efforts between Ecomotors and Solar Wheels constitute legitimate technological innovation. My lords, legitimacy is of utmost importance in terms of economic activities if any state is to develop economically, socially, or politically. It is the respondent's assertion that the collaborative research and development efforts by the applicants does not constitute legitimate technological innovation, and I shall be proving this in response to the applicant's submission, basing on 3 limbs of argument. The first being that the collaborative research and development efforts of the applicants did not result into products that meet the test of technological innovation. And secondly, that these products, the collaborative research and development efforts infringed on the patent of the respondents, and thirdly, that they violated the antitrust laws of Uganda. Moving on to the first limb of argument, my lords, the applicant earlier submitted that their products were innovative because they were new. However, my lords, according to Section 2 of the Industrial Property Act, innovation consists of new or improved products that are considered to be deserving certain intellectual property rights. Furthermore, my lords, according to Head Holistica, a journal on Business and Public Administration, Volume 8 of 2017, on page 60, an innovation is considered to have or consist a novelty. My lords, in reference to the facts, if I may please refer this, my lords, to page 2, paragraph 9 of the facts. The applicants came up with a technology with an SSC charging chip that accessed 8G ultra high frequency. This was earlier being produced by Green Drive. I beg your pardon. This was earlier being produced. This was earlier being produced in Wakanda. If I may please refer you to page 1, paragraph 3 of the facts. Therefore, it was in existence, and much as they may claim that it was new, there was no novelty in it, because there were already cars in Wakanda that accessed 8G ultra high frequency. And the cars, furthermore, the cars that they produced are also electric cars with SCC charging, remote charging technology.
And I think the applicant's innovation was the cost-effective ride-hailing service business. Were there other participants in the market that were dealing in this ride-hailing services?
Much obliged, my lord. There was no other participant in the market that dealt in ride-hailing. However, that is not a significant change, or it's not a new invention as far as that.
Were it not significant, don't you think your client, Green Drive, wouldn't have been as inclined to lock out or close all other people from accessing something similar? The network that enables it.
Much obliged, my lords. It is still the respondent's submission that this was already in existence. The electric cars that access 8G were in existence, and the applicants...
But perhaps they weren't cost-effective enough. In fact, the reason why they wanted to, from what I can see from paragraph 7, is that they needed to access it so that they can use advanced charging technologies to enable cost effectiveness. So you, on the other hand, had, yes, fast charging cars, self-driving and all that, but apparently it doesn't seem they was cost effective for the market.
My lords, in response to your question, we do agree that the applicants had the aspect of cost effectiveness in their intention to come up with these cars. However, it is nowhere in the fact that the respondents' electric vehicles were expensive. Therefore, my lords, it is our submission that there was no novelty, there was no improvement, and therefore their products, as a result of their collaborative research... So the absence of the facts mentioned in the cost means that it was not expensive? My lords, in response to your question, yes, the respondents submit that for as long as they produced the same product with us, it had the same features, it accessed the same ultra-high frequency, it is the same product, and there is no significant change in that, and therefore it does not meet the test of being a technological innovation. If there are no further questions, my lords, I beg to move to my second limb of argument, which is that their products...
Excuse me, Kans, how do you claim that or submit that it does not meet a technological innovation when they were able, much as you're able to limit them from accessing it, they would still have that service but using the 6 and 7 frequency? Don't you think there is some novelty in this regard?
My lord, in response to your question, the matter at hand is about them having produced the same cars, the cars. First of all, the same cars as the respondents with the smart charging chip, and that access the same network as the respondents. Therefore, we had no problem with them having produced cars that accessed 6G and 7G network earlier. However, when they came up with the 8G ultra high frequency, that is how we had to go to the work, because first of all, they were doing this without the respondent's license, and even it does not meet the test of being a technological innovation. If there are no further questions, my lords, I beg to move to my second limb of argument, which is that having established that their products did not meet the test of technological innovation, they infringed on the intellectual property rights of the respondents, particularly their patents. My lords, according to Section 2 of the Industrial Property Act, a patent is a license granted by the government giving a sole right to a company to exclude others from producing, selling, or vending the products as those of the holder of the patentee. I beg to persuade this honorable court with the case of Sazao Zaizami Electronic Technology Company Limited versus Shenzhen Yusheng Technology, a case of 2019 in the Shenzhen Intermediate People's Court in China, where it was held that the infringing chip that was produced by the defendant company constituted patent infringement, as it had the same integrated circuit layout design as that of the applicants. Furthermore, my lords, in the...
Excuse me, counsel. Let's distinguish that very case, the facts of that very case, and the facts at hand. What was being addressed in that case is not exactly what is being addressed here. Let's look at the background of this case. My lord, the leading judge, I think what also gives us the niche to really establish who has gone, why it has gone wrong, or there is a problem is what is the background. There is pollution, there is climate change, and like to still there is no alternative. It's like it's there to stay. Now there comes innovation, technology advancement on how to deal with this problem. I think this is one of the spirit under which competition laws came in, that let's create an environment where everyone is able to come up with innovations to deal with these challenging facts. Climate change is an issue, and it is there to stay as long as the human being is living. So the point is, by the time the anti-competition laws came up, the spirit was to ensure that novelty, let whoever is able to come up with an innovation to ensure that we deal with this problem is warmly welcome. Now, when we see the facts at hand, that you came up with an innovation which was very good, but you go ahead to limit other people from also innovating further. This is where I think the problem is. I don't see why you don't appreciate this, or because the facts are showing it. So our mandate as court is to see when we are dissecting exactly what is happening on the ground, and there are firms that are ready to innovate many applications to ensure that we deal with the problem. Meanwhile, notwithstanding your agreement, don't you think there is a problem? This is what we want directive to solve. The case you're referring to, this is not the problem that was at hand.
Much obliged, my lord. The respondent still begged this honorable court to find the case I earlier submitted persuasive, because the respondents are not against innovation in the state of Wakanda. In fact, we according to page 2, paragraph 7 of the facts, the applicants were earlier producing electric cars. These accessed 7G and 6G frequencies, and we were not against this.
But Council Katwanwachi, I think you've gone into very slippery ground, and it's very interesting. Now, you're saying that there is no innovation on the part of the applicants, right?
Yes.
Because the 8G capable SCCs were already innovated by yourselves, right? But let us dissect that innovation, right? What you came up with were chips that were able to do what? To tap into a frequency.
Yes.
You did not come up with a frequency. That frequency was some other person's, as they called it, relevant market, right? So if you have any industrial design to protect, it is the industrial design of the chip, right? When we look at these facts, do you have any other industrial design to protect, save for the industrial design of the chip?
Much obliged, my lord. The respondents are protecting both the 8G ultra-high frequency that is
You see, the reason I'm asking that is that you are... The Sky Connect, right, is a network provider, right? A different industry, right, and a different entity from Green Drive, right? Both of them are your clients, right?
Yes.
And what we're looking at is whether their undertaking was problematic, right? And I'm going to bring it back to, because we're trying to juxtapose those two undertakings. Your undertaking with Green Drive and between Green Drive and Sky Connect, with the undertaking between Solar Wheels and what's the name of the other? Solar Wheels and Eco Motors, right? Breaking those down, if you're saying that you had such a great innovation, which is the SCC chip, well recognizing that there are already in the market SCC chips, right? But you're also not the person that innovated 8G. The only link that 8G has to your industrial design, the thing you designed is not 8G. One of your clients manages the 8G frequency. You have limited them from giving access to that frequency, though that network, to any other player, right? Surely 8G is not your innovation. You have innovated something to tap into 8G. So is it really fair to suggest that that it would be an infringement on your design if someone came up with something different, designed differently, that somehow accesses 8G? Because notice that the licenses you complained about throughout this problem were not licenses to design chips. You are well alive to the fact that these people were designing chips. But somehow your problem seems to be that the chips, they somehow accessed 8G, which they shouldn't. But the only reason they are not being able to access 8G is not because it is protected by industrial design or a patent, because you don't have a patent over 8G. You have a patent over an 8G capable chip. Now, you see, the reasoning is that is like this. If I come up with an engine, that industrial design for the engine does not, let's say a petroleum engine, I do not have a patent over petroleum consuming engines or petroleum supporting engines. Other people can design petroleum supporting engines differently, provided they are not materially similar to mine. I do not see anything in these facts that points to the fact that the way their chips were made infringes your patent. Because remember, please, there is no patent over 8G that I do not see any inference that justifies a patent over the frequency itself provided by what there is a patent over the component. So I'm curious to know how it is that whatever they want to do with 8G is not an innovation, but yours, what you did with 8G is an innovation.
Much obliged, my lord, and in response.
But I hope my question is not too convoluted for you to understand. If I need to break it down, I can break it down. I'll accord you more time to answer.
In response to your question, my lord, Green Drive and Sky Connect are both our clients.
Yes.
And Sky Connect, one of the respondents, is the exclusive provider of 8G ultra-high frequency, according to page 1, paragraph 5 of the facts. So therefore, in this instance, my lords, it is Sky Connect particularly with a patent over 8G, because the applicants produced electric cars that involved both.
So what would you patent over a network? What would be the design that you're patenting? Think about it.
My lord, it is an invention, and therefore it's
No. You see, under the Industrial Designs Act, you cannot say I have this idea in the, I'm patenting, say, the cloud, right? There has to be some. So what industrial design do you think would be protected in the context of Sky Connect? Because the reason why I'm asking you these questions is that it seems you're under the impression that there is a component called 8G, ultra-high frequency, which is a separate patent enjoyed by one of your clients, and another patent that is enjoyed by one other of your clients, who is Green Drive. And that's, I'm interested in knowing what it is that they would be patenting under the Industrial Designs Act. What would be the industrial design that would be protected?
My Lord, in response to your question, according to Section 2 of the Industrial Property Act, an invention is a new art or design. Therefore, the respondents submit that the 8G ultra-high frequency was a new invention that had never existed in Wakanda.
I do not think that is true. All we can infer from Section 5 is that there is an exclusive provider of licenses to it. We can't infer whether they are sub-licensee. We can't infer whether they are getting it from anywhere. In fact, I do not see anything that suggests that they developed it. I want you to note the difference in the language between paragraph 4, which says, a new device developed by Green Drive allows for, that novelty is inferred in here. Sky Connect, on the other hand, is defined specifically. They do not say anything about novelty. They say it is a network provider that exclusively offers 8G frequency network licenses. There is a very significant, and the reason why I'm telling you this is that by the time we're dealing with networks are rarely something that you're dealing with in at a local jurisdictional level. Networks are things that cut across, probably have transatlantic cables, have satellites going into. So it's very unlikely that here we're having someone with a patent in Wakanda over 8G. At least the facts don't point us there. So if you're looking at an industrial design to protect, the only thing that speaks to novelty here in this fact seems to be paragraph 4. Where are you inferring the novelty for Sky Connect?
My Lord, in response to your question and indulgence, it is still the respondent's submission that we as the respondents hold a patent over the 8G. This is why, under the facts, it is stated that we are the exclusive providers. And so it is the same reason
let me ask now. I'm going to paint you a scenario, right? The exclusive distributor of Shell products in Uganda is Vivo Energy, Uganda Limited. Does Vivo Energy produce any oil?
My Lord, in reference to the facts at hand, the only reason as to why the JV was stopped was...
it's because it did not have licenses from the exclusive distributor.
And that, my Lord...
The reason I'm saying is that you are manufacturing the fact that you have a patent over this. I can accept that fact that you have a patent over this thing which you say is a new device. But there is nothing in the facts that speaks to there being a patent over 8G UHF. You notice that? Look at the difference in the language.
And besides, Council, it's not arguing for the sake of it. We are doing this to understand. This is a technical thing, area that is brought to attention. It is very clear that what you're managing or what you're owning is the smart charging chip only. And Sky Connect is just that firm, that authority that has exclusive license authority to offer licenses. But it's not a firm that has novelty under the 8 frequency.
Unless we can't infer it from these facts.
Exactly. And it is even a fact.
Yeah. And more importantly, by the way, I'm interested in you addressing that to the specific arguments of the applicant, to the effect that you're leveraging your dominant position in one market, right, to enter into an adjacent market and lock out foreclose other people from that market. So if the premise of that is that what I think erroneous assumption that Sky Connect also has a patent, which I do not see where you're deriving that. Exclusivity does not speak to patents. Because now, let me also now ask, Sky Connect has given you an exclusive license, Green Drive has an exclusive license over its 8G. Does that give you a patent over 8G as well?
My Lord, the submission of the respondents to the effect that Sky Connect has a patent over 8G is because the license was granted to Green Drive to produce its products. However, the license was not obtained by the JV, and this is why it was later on stopped. Its activities were stopped by the work. And
all those things are not in dispute. The thing that we are struggling with in your argument is quite simple. And I'm going to try to paint it again in petroleum terms. If I manufacture a petroleum-enabled engine, it does not mean I have a patent also over petroleum. If I manufacture an SCC chip that can access the 8G UHF frequency, it does not similarly denote that I have a patent also over 8G. Notice that I can enter into an exclusive agreement with a petroleum producer to say you will supply this kind of petroleum only to me, right? Because I have come up with something that can access that grade of petroleum, right? But does that make me have a patent over that grade of petroleum? You see the corollary. I'm trying to see if the analogy you're making, I think that the analogy you're making is fundamentally flawed, and that's the flaw I'm trying to get to.
My lords, in response to your questions, I beg to persuade this honorable court with the case of Kings versus Ford Motor Company that was held in the U.S. As my time is fast spent, I beg for a few more minutes.
3 minutes for that, because I have interrupted you.
Thank you, my lord. In the case of Kings versus Ford Motor Company that was held in the U.S. Court of Appeal in 2009, it was held that Ford Motor Company infringed on the patent of Kings as it was the innovator of the intermittent windshield wiper. And in relation to the instant facts, the facts that we as the respondents, first of all, we are the only producers of the SCC charging chip, and we are the only distributors
You're not
of
the
8G.
only. You're not the only producers of the 8G, rather the SCC. You are the only producers of the 8G UHF enabled SCC.
Much obliged, my lord, and it is to that fact that we submit that our patents were infringed on by the applicants.
By
My
doing
lord.
what exactly?
By producing electric cars, first of all with the SCC charging chip and with the HG ultra-high frequency, without us, the owners of the patent, granting them a license. That does not amount to, that violated and infringed on our patent rights and therefore does not amount to legitimate technological innovation. My lord's legitimacy is the extent to which a certain activity is in compliance with the laws and regulations in a state or in place, and this is according to Malas, Blank-Hestegin, and Bart Bansink in their article Assessing Technological Innovation in the Public Sphere. If there are no further questions from this honorable court, I beg to move to the second line of argument and conclude with our prayers.
No, I think just, state your prayers before the court.
What was
What
the
was the
second
second
limb?
limb? Yeah.
In response to the applicant's submissions, they stated that they did not violate the antitrust laws of Wakanda, and as they did not in any way cause an anti-competitive effect in the market. However, I beg to refer to Section 5.1 of the East African Community Competition Act that prohibits any concerted activities that may cause
I
an
think you're
adverse
addressing a
effect.
whole issue, not a limb of argument, right?
My lord, it is in response to what they submitted on legitimacy of technological innovation. Yes, so in response to that, Section 5.1 of the East African Community Competition Act prohibits any concerted activities that may result into adverse effects on competition, and these include collusive price fixing, collusive tendering, and bid rigging, among others. In relation to the instant case, according to page 2, paragraph 13 of the facts, it shows that the JV, the applicants, shared sensitive business details and pricing strategies. My lord, it is the respondent's submission that these strategies included price fixing, and therefore this violated the antitrust laws of Wakanda as it was anti-competitive in nature. My lords, it is therefore our conclusion and submission as the respondents that the collaborative research and development efforts by the applicants do not constitute legitimate technological innovation, as they do not meet the test of being a technological innovation, they do not comply with the intellectual property law of Uganda, and they are against the anti-property laws of Uganda. It is our prayers, my lords, to this honorable court is for a declaration that the exclusive agreement between Green Drive and Sky Connect does not amount to an abuse of its dominant position, that the collaborative partnership between the companies of the JV amounts to an anti-competitive cartel, that the collaborative research and development efforts between the companies of the JV do not constitute legitimate technological innovation, and costs of the suit, my lord. If I am of no further indulgence to this honorable court, I beg to submit.
All right, thank you. We have rebuttal. Okay.
Your Lordships, our eyes on the floor. Without wasting too much of this court's time, I will summarize the rebuttal of the applicants. My lord, the respondents have opened a wide door in patent law, and with that, we are going to engage them specifically on one limb of their argument, and we shall dispose of that matter, for which we also pray that you are inclined to dispose it of. My lord, it is settled law under the Industrial Properties Act that there are 3 requirements that should exist. Section 9, 10, and 11 specifically provides for nobility and innovative step to innovate, and whether that innovation is industrial applicable. We are not contesting that on the smart charging chip. However, my lord, the fallacies that come from the respondents are that they invented the 8G ultra high frequency network. Now with that, we submit, basing on the Kenyan decision in the High Court of Kenya in 2014, the famous Beans case, which is Beans Kenya Limited versus Santama. The question before our court was whether a distributor of dust bins can have patent rights like the producer or the manufacturer of those bins. The answer in court was that no, distributing bins does not in itself mean that you have patent rights over those bins. So with that, we pray that this honorable court is inclined to apply that persuasive decision in this matter, that Sky Connect only licenses Green Drive to use the 8G ultra high frequency network, and that Green Drive did not in itself innovate and come up with the 8G ultra high frequency network. My lords, on the other issue is that they submitted that there was a collusion between Ecomotors and Solar Wheels to come up with an anti-competitive cartel. My lords, we submit that there was no collusion. In the famous case of Courage versus Graham, the UK House of Lords was clear and said that collusion is when 2 companies or 2 actors in the same field come up and join hands and they become one to establish anti-competitive practices like decisions, arguments, and concerted practices. It is our submission that the joint venture is independent of the 2 companies, Ecomotors and Solar Wheels, where they only entered into a joint venture to innovate the cost-effective ride-hailing service business, and that does not in any case connect to their role of manufacturing of electric vehicles. With that, we pray that this honorable court is inclined to find that there was no anti-competitive practices from the joint venture, and that the court finds that issue in the negative. My lords, to conclude our submissions, it is clear that the applicant, the respondents, have failed to show this honorable court that indeed they did not own a dominant position as Green Drive, and that they did not use that position to violate anti-competitive laws. We submit, my lords, that the exclusive agreement between Sky Connect and Green Drive foreclosed other competitors from meaningful competition, and as such it prejudiced them in competing in the market, and as such Green Drive also leveraged its power from manufacturing of electric vehicles as stipulated under paragraph 3 of our facts, where it had a significant market share and leveraged the same dominant position in the smart charging chip technology. With that, we submit, my lords, that there was a dominant position by Green Drive and that Green Drive used that dominant position to violate anti-competitive and antitrust laws. My lords, with that, the applicants rest their case, and we pray that this honorable court finds that Green Drive had a dominant position, violated it, and on issue 2, that there was no anti-competitive, that the JV did not turn into an anti-competitive cartel, and under issue 3, that the collaborative research and development of the joint venture was clearly for legitimate technological innovations. We submit, my lords. Thank you very much.
May it please this honorable court, I am Cavendish once again, and in rebuttal to the applicant's rebuttal, the applicants rebutted that we as the respondents failed to prove that Green Drive was the patent holding producer of HG ultra high frequency. And we do not dispute that. As I earlier submitted, my lords, one of our clients is the exclusive provider of HG ultra high frequency, and I beg to apply the literal method of interpretation of the word exclusively. It means we hold the patent over it, and the other companies that are to use it are to obtain licenses from us. Therefore, it is our submission that our patent was infringed on, as we were the patent holders. Secondly, my lords, in rebuttal to the applicant's submission, the applicant submitted that the companies of the joint venture were independent of each other. However, I beg to use the definition of a joint venture according to Section 2 of the Competition Bill of 2002 of Uganda, that provides that a joint venture is an enterprise with joint control by two or more undertakings. They are simply economically independent of each other, but we have joint control by the undertakings. Therefore, this does not eliminate the fact that they even exceeded this control by sharing sensitive business details and even pricing strategies, which makes the applicants their collaboration to amount to an anti-competitive cartel. And lastly, my lords, it is in response to the applicant's earlier submissions. The respondents did not abuse their dominant position because the exclusive agreement did not in any way drive out other competitors from the market as seen in the facts on page 2, paragraph 7, where the JV was also involved in this market and dealt in the production of electric cars. With this, my lord, it is the respondents' prayers that this honorable court finds that the exclusive agreement between Green Drive and Sky Connect did not constitute an abuse of its dominant position. The collaboration between the JV companies amounted to an abuse of its anti-competitive cartel. The collaborative research and development efforts between the applicants did not constitute legitimate technological innovation and costs for the suit. I beg to submit.
All right. Well done for coming to the end of your second round today. I do have comments.
Time.
Yes, time. Okay. We wish you all the best for the team that will go ahead to the semi-finals, and yeah, may the best man win.
There's one more preliminary round. Same as after this.
Yes,
It's same as after this.
preliminary.